and this is a huge warning, is there's tons and tons of fraud happening in the landlord and tenant board world. And I get asked of 100,000. I had an ask of $1 million. I mean, there's some really ridiculous asks. Of course, we didn't pay that. Damages arising from the acts of the landlord, and fines. So it could cost a landlord $100,000 to do that.
Wow.
And there are some Facebook pages with tenants groups that are encouraging, the assumption is that every landlord is wealthy beyond imagination.
Today we are in for a treat because we have a very accomplished paralegal with us, Elaine Page, and you've been doing this for about 30 years or so?
30 years.
30 years, and she is a friend of Mark Morris, who is a regular on this channel. So I think, I owe Mark a thank you for this, and obviously you're taking time off of your day.
So thanks for having me. Appreciate the opportunity to speak to you and to everybody else today. Yeah, so I'm a licensed paralegal, and when I say that, a lot of people don't know what that actually is, so I thought I would just say that first.
Yeah.
We are licensed with the Law Society of Ontario, and we follow the same rules and regulations as lawyers do. So because of that, we are allowed to appear in places like the Landlord and Tenant Board Tribunal as representatives. Okay, so now let's talk about grounds for termination. So there are different grounds for termination of a tenancy. And the one that is not a ground for termination of a tenancy is that the lease has expired. The lease automatically becomes a month-to-month lease. So we get a lot of people saying, well, it's up in June. How come they're not leaving? Well, tenant doesn't have to leave. So the grounds to terminate a tenant for non-payment of rent, persistent late payment of rent, behavioral issues such as causing disturbances, illegal activities going on in the unit, so that's generally drug dealing. And then we get into owner's own use, purchaser's own use, and demolition or renovation. So a quick walkthrough is that on those owner's own uses and purchaser's own use, it is a 60-day end of term notice. So what that actually means is if your term expires on June 30th, then you cannot have a termination date prior to June 30th.
Right.
There are requirements that go along with these notices. So if it's an owner's own use application, that means that the owner or their child is moving in, and they actually have to move in. They can't just leave it empty for a year. I get requests for grandparents and cousins. No, it's a very specific set of criteria. And on the purchaser side, so now you've got a property that's for sale and a purchaser wants to move in themselves. Again, you have to actually have the purchaser move in and live there for a period of no less than 1 year. And somebody is going to call me out on that because Section 48 deals with one thing and Section 49 deals with another. And on one of them, there is no requirement to stay there for a year. But the way that the board kind of intertwines the two, so I always just make a general statement that you have to stay there for a year. So now we've got a scenario where we want to put a property up for sale. And it's a tenanted unit. And let's, for argument's sake, keep it simple. The rent is payable on the first of the month, and the tenant is on what's known as a month-to-month tenancy. So you get an offer in. And the problem becomes that it's a vacant possession offer, and it's a short closing. And this is where we bump into all sorts of issues, because the process of the Landlord and Tenant Board to terminate a tenancy for purchaser's own use can take 8 to 10 months from start to finish, which makes it incredibly difficult to sell a tenanted unit. It's also why a lot of people stay away from selling a tenanted unit.
Mhm.
And it's also, I don't have to tell you, that failure to close carries with it a whole other set of problems and
Mhm.
conditions and monetary relief.
Mhm.
So the idea is if the tenants, you want the tenant to vacate, you have to serve them with that notice. And so I don't recommend doing a 2-month closing, by the way, ever.
Okay.
And I know that can impair the ability to close. I get that. Or to sell because people want fast closings. I get that. But I don't recommend it just because the timelines don't make sense. Um, so now you've got a scenario where you've got a 2 or 3 month closing, you've got a tenant there, and you serve them with the N12, which is the notice of termination for purchaser's own use.
Mhm.
And they say, I'm not going.
Right.
So now we get into a cash for keys situation where you essentially have to balance what is the penalty, can I get an extension on this closing? And if so, how much of an extension? Um, and what's the potential monetary risk for me if I do not close?
Mhm.
And that's sort of what you need to think about when you're negotiating cash for keys. So you kind of get a sense of that, and then you look at them and you say, okay, so the tenant's been in the unit for an extended period of time. The rent is relatively low. It's $2,000 a month. To get the equivalent unit in this market, they're looking at a differential of $500 to $1,000 more a month.
Okay.
So then we look at that and say, okay, what is a reasonable amount of money to pay them to incentivize them in order to leave? And I get asked of 100,000. I had an ask of $1 million. I
Oh,
mean, there's some really ridiculous asks. Of course, we didn't pay that.
oh my.
There's some really, really ridiculous asks out there. And there are some Facebook pages with tenants groups that are encouraging, the assumption is that every landlord is wealthy beyond imagination,
Right.
I mean, which is a false assumption, of course. I get so
Yeah.
many people who are losing their shirts because they've had to refinance their mortgage at 5 times the rate they had
Yeah.
it previously, right?
Yeah. Yeah.
So you get some radical people who put these crazy ideas into tenants' heads. So if I think about, all right, how much does it cost to move? We're going to say about $1,000 to $1,500 out on average, and the rent differential for a year is $1,000. So now we're into $13,500, and
Mm.
to me, that's your high end of the scale.
Okay.
Because if I mean, it just makes sense. It's a reasonable way of calculating the difference between where the tenant is presently and where they are. And most of us working in the field um, use that formula. It's a
Okay.
very common formula to be using. So that's kind of where you're looking at. And I don't pay money up front. I never recommend it. I recommend paying a portion of the money up front because the tenant generally will need that money to pay first and last elsewhere.
Sure.
They'll also potentially need some money to help with the moving expenses. So we draft up a proper agreement, and then with what's known as an N11, which is an agreement to terminate the tenancy, and everybody signs off on it and includes full and final releases. And then on the day that the tenant vacates, they're handed their second check.
Okay.
And if they don't vacate on the day that they're supposed to vacate, they not only do they not get that check, but I draft these up so that they actually have to repay the initial amount because they're in breach of an agreement.
Mm. Mhm.
So that's the principle behind it. Now, if you have a tenant who is not interested in taking a cash for keys deal. And there's lots of people who aren't, especially if the tenant has children, you're in the middle of a school year and they don't want to leave,
Right.
you may have to think about whether it makes sense to have this unit on the market.
Right.
So really the best case scenario is, and I'm somebody who's a very upfront person. I like honesty. I like to deal honestly, and I like it when people deal with me honestly.
Hmm.
Um, so my advice is, before you even go to market, sit down with your tenant and say, we're in a financial crisis at the moment. I just got off the phone with a client 5 minutes ago. Mortgage, the mortgage is now tripled or what it quadrupled, and they can't, and the rent is well below. It's not covering it, so
Right.
they're losing $2,000 to $3,000 a month, and they can't afford to go on in that vein. So, my advice to them is to go and talk to your tenants. You have a relationship with your tenants. Explain what your situation is. Let them know that you're planning on selling, and see if you can arrange a cash for keys deal ahead of going to market, because it's much, much easier to sell a vacant unit than it is to sell a tenanted unit. So
Right.
that's generally the principles that I like to work with. And I think, often tenants understand that. They, when they're ready to move, I mean, we certainly get our difficult tenants, no question about it, but most people are pretty rational and understand. Where we sort of bump into the big problems is when we have tenants that have 15 or 20-year tenancies and they're living in like a 3 bedroom
Yeah.
with a loft and a backyard, and they're paying like $1,000 a month. Those are the people that we're having much more difficulty with.
Okay. Okay. So
So that's it. Yeah.
sorry, so it's not just enough that like sometimes the sellers will say, okay, I want to sell, and then it's tenanted, but we're on good terms, don't worry about it. I know, like if
No.
I ask her, she'll move. Like that's not good enough,
Oh,
obviously.
I hear that
Get
all the
everything.
time, and
Yeah.
often people are quite surprised to learn that no, they
Right.
won't move.
Yeah, because
So,
sometimes the tenant could have good intentions. They want to be, okay, nice to the sellers, but they've been living there for 2000. They go start looking. Now everything's for 3500. Then they're like, oh,
they
wait a
can't
minute.
afford
Like,
it.
maybe I'll look around. And then they go on these Facebook and Reddit groups and they're like, oh, what's cash for keys? Right. And then they get all these ideas. Not saying every tenant is like that, but I've
No,
seen that happen where they change their
sure.
mind. So,
And
yeah.
they're also there's like so much information available for tenants. So what ends up happening is they recognize that the board is still delayed and that it's 8 or 9 months before it actually gets to a hearing. And then, another month to get an order, and another month if we have to call the sheriff in. So, the evictions get delayed by a year,
Mm.
which is a real problem when you're trying to sell a property.
Course, yeah, especially if you're stuck, like you need the money out, right? Yeah.
Right, right.
So just like let's say you get the hearing in like 8 to 10 months, even just that hearing, that's not really a guarantee that the landlord's gonna win, right? Like it
No,
could go either way on that.
it could. So there's a certain statutory requirements that you have to meet. So first of all, if your notice is defective, which again, we see lots of defective notices, you cannot amend it. And so so like a lot of people will say, for example, termination is on July 1st.
Okay.
If the rent is due on the first of the month, then termination is not due. The termination date would be the day before the first of the month, so June 30th in this case. So
Mm.
that would be considered a defective notice. It'll get thrown out.
Mm.
If the other statutory requirements are that the landlord must pay 1 month's compensation to the tenant before the termination date. A lot of landlords say, well, I'll give them the money when they leave. And if that termination date has expired and the compensation hasn't been paid, your
Mm.
application, there's a good likelihood your application will be dismissed.
Mm.
And the other thing that fails is what we call the bona fide. So that this is sort of the thing that gets challenged the most. Does that person legitimately require the premises for their own use? And we get cases where, especially on owner's own use, where I had one, for example, it was a basement unit of a bungalow that had not been particularly renovated since the 60s or 70s. And the mom lived upstairs. There was a tenant in the basement, and the tenant, mom did not like the tenant. She wanted to get rid of this tenant. And so they filed a notice that the son was going to move in to the basement unit. Well, the
Mm.
son lived in a 3,000 square foot or 4,000 square foot home
Okay.
in Richmond Hill with his 4 children.
Okay.
There was no marriage breakup. And so, we challenged the bona fide, and obviously it seemed ridiculous that this guy was going to live as his full-time residence in his mother's basement when he had this
Yeah.
beautiful home in Richmond Hill.
Right.
So they lost. So that's
Oh.
something that happens all the time where we're challenging the bona fides. And I would also say to you that, we get a lot of people who think they're smarter than everyone else and concoct these scenarios that they think might work and do an eviction based on that. And there's real penalties, like huge
Yeah.
penalty for falsely evicting somebody.
Yeah, that's what I was gonna ask. Like, what if, let's say, the owner says, "Hey, I can get double the rent. I'll just say I'm moving in, get them out, wait a month, and then put it up for rent, and then get like
So
4,000
that,
a
yeah.
month." So
So
like,
that's something called a T5 application. So let's say we have a tenant who's vacated on the N12,
hmm
and a month later, the property's either up for sale or up for rent. There's a listing.
right.
So automatically, the tenant that vacated is in a position to file what's called a T5 application against the landlord.
Okay.
And the fact that there's a listing for like more rent than what
Yeah.
the initiating tenant paid, that's sufficient proof
Yeah.
to say that the landlord acted in bad faith.
hmm
And then the test at the board becomes that the landlord has to prove that they did not act in bad faith, that something substantial changed, and therefore they didn't act in bad faith.
Mm.
So when we get those applications, the remedies are the difference in rents between what they were paying and what they're now paying
Okay.
for a year.
For a year. Okay.
So, so if they've moved out and they're paying $1,000 more a month, then it's a 12,000. Their moving expenses, as well as damages arising from the acts of the landlord, and fines. So it could
Mm.
cost a landlord $100,000 to do that.
Wow.
Yeah, they just raised all of the bar on this and the
Oh,
amount
wow. That
to
high.
deter people from doing it.
Yeah, yeah, yeah. Wow. I didn't know it was that high. Wow.
Yeah, we're seeing some huge awards now.
Oh, so they have been paying out those that amount.
Yep.
Wow.
So that it's really to discourage fake, false, bad faith notices of termination.
So, like, when you go into courts, I mean, you see a lot more detailed stuff. Like, is it pretty much 50-50, or do they usually favor the tenants because all landlords are millionaires in their mind? Like, how does it
So
kind of play out?
it's balanced. Um if you were to ask landlords, they would tell you that it's biased towards the tenants, and if you were to ask tenants, they
Okay.
would tell you that it's biased towards the landlord. So it depends on the
Mm,
situation.
okay.
Um, there is, one of the things that people sort of need to recognize is this is housing. This is people's housing. We have a lot of people who have very low income, who are have medical issues,
Hmm.
and so we have what's called Section 83 issues, which is things that the board needs to consider before terminating a tenancy. You know, we've got somebody who's in palliative care, not likely to be able to evict somebody in that situation.
Okay.
Um, or other serious medical issues. So the Section 83, which is basically under human rights, explains what's going on, and the board has the authority to delay or deny an eviction based on legitimate Section 83 issues. So it really depends on the adjudicator, and it depends on what the issues actually are. So, for example, we might find that we have a tenant who's in arrears of rent, but they can verify that they just got a job and that they'll get money, you know, they'll start to get a regular paycheck in 2 weeks' time.
Hmm.
So the board might give them a payment plan instead of evicting them, depending on what the arrears are. Um, so I would say, you know, especially since um I've been doing it as long as I have, I would say the board is quite balanced.
Okay. Yeah.
And and the adjudicators work hard at being balanced. And of course, if you're on the losing side, you feel hard done by.
Right. Yeah, of course. On the missed payments, like, is there like a set amount? Like, okay, you missed 3 months of rent, so it's
No.
automatic, or it's like kind of.
So once a tenant has missed a payment,
Mhm.
a lot of landlords wait before issuing what's referred to as an N4, Notice of Termination for non-payment of rent. My advice is don't wait.
Okay.
Like 2 or 3 days is fine, but after that, you should be serving your notices because it also takes 4 months to get to the board to get a hearing. And you know, that potentially can add up. We have rents that are five, six, $7,000 a month, and the board's jurisdiction is 35,000. So if you know, you might end up exceeding the jurisdiction, and the board won't allow will not make an order for that money. So I don't wait, because the board is still backlogged.
Yeah. Is it getting worse, the timelines,
No.
or the waiting period, or is it getting better?
It's getting much better for arrears applications. So we're now, you know, from the time I file the application, it's about 4 months to a hearing to get to a
Okay.
hearing. Whereas during COVID, it was 10 months to a year.
Wow.
So
Okay.
it's definitely getting better. The owner's own use applications, demolition, those sorts, renovation, those sorts of applications are still 10 months.
Okay. Okay. Sorry, I'm not distracted. I'm looking at the couple of people
That's
sent
okay.
questions on my YouTube. Uh, like how much, I know you highly recommend like hiring a professional, and like what could be the cost for a paralegal to handle something like this from the
So
landlord
it
side,
really
I guess. Yeah.
depends if we're talking about arrears case or something different. There's a
Okay.
wide range of fees that
Mhm.
so it's always $186 is the application fee.
Mhm.
And if we need the sheriff, that's between 320 and 340. I don't know, you know, to hire somebody like me who has 30 years experience, my rates are certainly higher than somebody who's been doing it for 6 months.
Of course.
Um,
Of course.
so it's about 12 to $1,500 to do it start to finish,
Okay.
plus the disbursements.
Okay. Um, any, so what, like just for fun, I guess, like what's the highest you've seen in terms of cash for keys, and if it actually went through?
Yeah, so I was working on a project for some developers and we were habitually paying out 30,000.
30,000. Okay. And is it higher in Toronto, or is pretty much
Yeah, it's higher in
spattered?
Toronto
It
because
is.
the rents in Toronto and the GTA are significantly higher than in, some of the
Okay.
smaller towns. So, yeah, and it's also available. The existing rent is higher, and the rental market is tough. Like it's
Yes.
hard to find a place. And that's one of the other things I should mention that's happening is that you're not allowed to take more than, first and last month's rent, but we've got allowed landlords who are demanding 5 months, 6 months up front,
Yeah.
and they're veiling it in. If a landlord offers it, sorry, if a landlord makes it a condition of the rental,
Hmm.
then it's not legal. But if the tenant offers it, it is.
It's okay.
So there's often these negotiations going on behind the scenes between the realtors, say, and so the landlord's realtor will say to the prospective tenant's realtor, yeah, like this is the credit bureau isn't great, so we
Yeah.
need 6 months up front. Put
Right.
it in the offer. Wink, wink.
Yeah. Yeah.
Well, a lot of those things are falling apart now because it's obvious of
Hmm.
what's transpired. So as soon as a tenant gets in,
Hmm.
they're going to the board and saying, I want all that money back, and the board will order it. And the
Wow.
other thing I want to just make sure, because as I said to you before when we weren't rolling, I can talk about this stuff for hours, but
Yeah.
one of the warnings I want to give people, and this is a huge warning, is there's tons and tons of fraud happening in the landlord and tenant board world. So we're getting fake credit bureaus, we're getting fake applications,
Oh,
and people are not checking those, and so they're renting on that basis and getting ripped off. I have one guy who ripped off his landlord. I think by the time we got him out, it was about 35,000.
wow.
And then a month and a half later, a new landlord called me and said they got a problem with this guy, same guy, and he's been sitting in the unit for 5.5 months. We have a hearing coming up, and into the landlord for about 25 at this point. And this, if I looked at his application, it
Yeah.
was a completely false application.
Really. Wow.
So one of the things that if you're doing this kind of work, you should not just be accepting credit bureaus from tenants. You should actually go and do your own credit bureau.
Hmm.
And there's a website called Open Room, OP, oh, sorry, excuse me, Open, OPEN, room, ROOM.ca.
Okay.
And many of the landlords are now posting orders from the landlord and tenant board on that site. So if I were to give you the name of this gentleman that I was just talking about and you plugged it into that site, it would show that he's
Okay.
got orders.
Mm.
So I strongly recommend spending the 25 or 30 bucks to do a credit bureau
Yeah.
and do it, and not just accept ones from tenants.
I think that's really important because yeah, like you're like, oh, I don't want my credit to get damaged, so I already printed one credit report, so I don't want you to do a credit check, so I'm just sending you the what I have.
Right.
That's not
And
good.
so interestingly, I mean, I've done a few cases where they've converted on that basis. The fraudulent credit bureaus and applications, they've converted these luxury homes into rooming houses and
Yeah.
just destroyed the places. And you can check, CBC did a whole report on that.
Right.
And that's what this particular individual did. He used a false credit
Mm.
report. And when I asked the detectives that I was working with about that, like, and the answer is apparently it's not fraud, apparently, to create a false credit bureau because it's considered art.
Oh, wow.
It,
Okay.
it is it is problematic though, that shifts when you start using your art to deceive
Yeah.
somebody into
Yeah.
into allowing you a unit based on
Right.
it. It's quite
Right. Wow.
interesting, and I don't practice any criminal law, so
Yeah.
so
That's
I was shocked to hear that.
Yeah, that's a good spin on it.
I see quite often is real estate agents trying to represent people at the landlord and tenant board. Well, you're not allowed to. So what I see happening is agents will go in and say, yes, I'm representing someone. They'll be asked if they're a member of the Law Society. The answer is no. And then the adjudicator will say, well, I'm sorry, I can't hear you. You have no standing. The client's somewhere else, and now the file has gone awry. So we
Mm,
don't encourage agents to appear there. And the other thing is, there's a real question as to whether or not your errors and omissions insurance would cover you if you screwed up at the board. So that's my first thing. And the second also that goes with that is to say that you should not be filling out landlord and tenant board forms either. Because we see lots and lots of mistakes by agents. And then what ends up happening is it gets to the board, and because there's an error in the initial notice, and we've now waited 8 months to get this thing to the board. If there's if there's an error in that notice, then the whole case gets dismissed and you have to start over again. And
oh,
again, agents don't always, their errors and omissions insurance may not cover them for that. So we really try to encourage agents not to fill out those forms and to stay in their lane.
yeah.
So the big thing is, and just on that note, and I'm going to dive into cash for keys for you. The other critical area that I see from agents is not using the Ontario Standard Lease Agreement. So we're still using that Form 400, which I get that you have to use because your commissions are based in that structure. But on top of that, you must also be doing the Ontario Standard Lease Agreement, and that is downloadable on the internet. You can find it and needs to happen.
I've got about 4 minutes. Any
Okay.
words of wisdom from your 30 years of experience? Anything you want to say about yourself? Like anything, traps
Sure.
to avoid?
Yeah, well, the biggest trap to avoid is to ensure that if you're going down this road, that you use somebody. It doesn't have to be me. I've got lots of great colleagues out there. You use somebody who knows what they're doing, and this is a massive uh, uh, um, sorry, I lost my language there for a second. This home that you're selling is a huge investment. It's a massive asset was the word I was looking for.
Mhm,
You
mhm.
want to protect it and yourself as much as possible. So please use professionals to deal with it, and don't try to navigate it yourself.
Right, right, yeah. Uh, Quickly, this is going to be a quick question. Let's say somebody rents it for himself, and then you find out there's like 10 people living there.
There's an
Is that a
application
reason enough?
available.
Is that a reason enough to, get it?
Potentially, depends on how big the unit is.
Okay, okay,
It's all, but there is an application available if that were the case.
okay. All right. Thank you, Elaine. Thank you so much. You did not have to do this. I really appreciate it. Please, I will leave all her info down at the bottom. So if you guys have any questions, please reach out. She was great. Like I said, didn't have to do this. So I'm very thankful. Anything you want to add before we go?
No, thank you. Thank you for having me. It's a
Yeah,
pleasure, and I'm happy to answer questions. And
for sure. Yeah.
yeah, thanks. Thanks again. Appreciate it.
Okay. Okay. Thank you, Elaine. Okay.
Okay, bye
All right.
now.
Take care. Bye-bye.